Hello everybody, this is Dr. Ram Kasi Vishwanathan from Aja Commerce Academy, Hyderabad. So, this video is part of a lecture which we were intending to be addressed towards CA final students for the subject of income tax. Now, the general advice that we give to students of CA final in the paper of direct taxation is that look at this area of international taxation. Okay, so the weightage is somewhere between 30 to 35 marks. Okay, and when you compare the syllabus with the rest of the Income Tax Act versus what has to be learnt under the international taxation purview, you will know that this is a cash cow where you have very few topics to study, easy to master. Okay, so it becomes then imperative that you cover this area very well. Now in this scheme, international taxation is actually making the direct tax paper a very scoreable paper, given the fact that MCQs can also be picked up from this area. Now, the topic that we have picked for discussion today is a very crisp and practical topic. Okay, this is on double taxation avoidance agreement. Okay, what is the background of this topic? See, when we have individuals who are residents of a country but working in some other country, right, then their taxability now falls under two jurisdictions. One, the jurisdiction of their residence, and then two, the place of employment or work. Now think from an India point of view. So we have several of our citizens or say residents who have residential status in India, but they also work outside in several countries on different roles. So it brings here a legal complication. The complication here is, since this person is resident of India, okay, we have to apply the taxability norms, and based on his residential status we have to tax him in India. At the same time, this person who is working in another country, according to the domestic laws of that country, has to pay tax there also. Now, isn't this a double whammy for this person, having to pay tax in both places? So this behooves that there's a relief that has to be granted to this person. So this chapter on DTAA talks about double taxation relief. So what kind of relief is available in the provisions of law to a person who is positioned like how we discussed now? So this is basically covered in sections 90, 90A and 91. So what happens typically is India has entered into double taxation avoidance agreement with several countries, right? Now, if you are fortunate enough to work in a country where there is a DTAA that subsists between India and that country, then your relief is almost natural, because as part of that agreement, it is then decided between the two countries that who will choose to tax, correct? And this may change on an agreement to agreement basis, correct? Now, there may be a question that what happens if the provisions of Income Tax Act 1961 wants to tax it in a certain manner, and then it enters into a conflict with the provisions of DTAA with that country. So it is a maintained position in law that the provisions of DTAA will overrule and prevail over the provisions of Income Tax Act 1961, which means those provisions will be applicable. Now, what kind of reliefs can be given? So there are two kinds of reliefs that are available. One is called a bilateral relief, and the other is called a unilateral relief. Okay, now bilateral relief comes into existence when the agreement is existing between India and the other country, and there is a chosen method of giving the relief. So basically there are two types of bilateral reliefs that can be given. So one is called exemption method and the other is called credit method. Now the name is self-explanatory. Under the exemption method, so what happens is if the income has been taxed in one country, then it will be exempt from taxation in the other country, mostly in the resident country, because practically what cannot be avoided is the place where you work and earn your livelihood will not give up the option or the privilege to tax you. They would not like to waive it towards the favor of the country where the person has a residential status. So, assuming that on the foreign land, based on domestic laws, the assessee has been taxed, under the exemption method, it will not be taxed in the country of residence. Then the other method under the bilateral relief is called a credit method. Under the credit method, what happens is the tax paid in one country is calculated as a credit, and then it is positioned against the tax payable in the resident country. And to the effect tax is already been paid, it is reduced and only the remaining amount has to be paid. Now if you observe, in both these cases, the assessee carefully only pays tax once. So there is no question of double taxation, and also where he is not able to get an exemption, he gets a credit for the payment made and thereby does not pay tax again. Now, so I told you the agreements, the DTAA, double taxation avoidance agreements, are entered between India and other countries. Now, this provision has been extended to say that not just between the governments of two countries, but also between organizations, associations, companies, etc. of two countries, where the question of double taxation can arise. This is basically diluting the role of the government, where governments want to follow a laissez-faire policy and say that where possible you please handle the business by yourself and involve us only when needed. Correct? Now in that direction, the next kind of relief is called unilateral relief. Now this unilateral relief is applicable when a DTAA between the resident country and the source country. So source country where the income is earned, resident country where this person belongs to, such an agreement does not exist. Okay? In that case, what do we do? When there is no agreement, what do we do? See, the idea is an existence of an agreement or not should not discourage movement of resources, talent between two countries, so that both those countries can get enriched. Just to avoid such a discouraging effort is not made, what happens is the resident country on its own initiative will offer relief to the residents. So section 91 of the Income Tax Act provides that under the framework of unilateral relief, the home country will allow a credit for the tax paid in another country on the income that is derived from that country. Now that means this has to be done through a computation, right? Now let's look at the computation in the next video. Thank you.